Thank you very much. Minister, if Bill C-48 on bail reform had been in place in Canada for the last 5 years, how many criminal offenders would have stayed in jail as opposed to have been released on bail? Given the conditions that you described in your opening statement, it sounds to me like this Trudeau government bill has a very limited scope, and so my guess is that the actual number of offenders this would actually apply to is tiny.
So, first response is that it's difficult to respond to that with exact precision, because as I mentioned at the outset, Senator Batters, that the data which is accumulated at the provincial level is not as sufficient as it needs to be. So what I would say to you as a senator from Saskatchewan is that I would encourage you to reach out to your Saskatchewan colleagues and encourage them to ensure that their data is more robust. Second point I would say to you is that with respect to on the sort of the logical supposition is that a bill like this, which makes bail not impossible, but much more difficult to receive, will result in less people who are serious, violent, repeat offenders who use weapons being out on the streets prior to their trial. Ipso facto, that means unless they're committing a crime inside of a prison, there's likely to be less criminality. So I think this is a step in the right direction, but I cannot provide you that data because despite my pleas for better and more accurate data, some provinces have stepped up to the plate on that, but not all provinces have.
Well, Minister, I mean, I received a similar sort of response from the government leader in the Senate, who the sponsor of the bill, who's here with us today, when I asked him about this, and he stated that your Justice Department had no data on bail decisions made by judges over recent years and on the number of offenders to which the bill would apply. So are you actually saying then, when your department drafted this bill, and your predecessor, I guess, who drafted this bill, that you did not conduct an assessment to determine how many offenses would actually be covered potentially by this bill?
We absolutely did an assessment with respect to the offenses, and that's why you see a targeted measure that relates to repeat violent offenders. Well, I'm not sure I understand your question because I think you're asking two different questions. One was how many people have not, how many crimes would have been prevented, but the second part of your question now is in respect to what kind of analysis did you put in to verify which types of offenses would be caught? It was very specific. It was very targeted at people who are repeat violent offenders. I gave you the definition of what constitutes repeat violent offenders. And what we heard from communities right across the country, including from your own province, particularly on the prairies, is that bladed weapons are a problem in Saskatchewan. Bear spray is a problem in Manitoba, for example. And we took great lengths to address those very concerns. So the concerns were expressed by provincial premiers, and the premier of your very own province of Saskatchewan is absolutely behind this bill and has indicated as much quite publicly. So I think that's an encouraging sign. So obviously we looked to the information that we had before us with respect to who had the highest likelihood of repeat offending. And we also heard, importantly, I see everyone wearing orange shirts. That's terrific. You have an orange shirt day here in the Senate of Canada. We heard from Indigenous communities that said it's also important for you to mandate, which we are doing via this bill, for judges or JPs who are making bail decisions, that they have to consider the impact on a community of releasing a person back into the general population. And we heard that directly from Indigenous communities across Canada.
Minister, yes, what I was actually asking about in both those questions was about the number of offenders that this bill would have applied to in the last 5 years. So perhaps maybe your departmental officials, I can get into that in more detail in the next hour. But, and certainly the premiers of the provinces support significant bail reform, but what they want to see is actual significant bail reform. But I'll have to move on. Minister, where is your GBA Plus document? Because as I've said a number of times to your predecessor at this committee, it is much more helpful if we can receive your GBA Plus document before you appear here rather than after. And Minister, a portion of my personal gender-based analysis on this Bill C-48 would be that this bill is much too narrow in scope, and as such, it leaves too many Canadian women who may be victims of serious violent crime vulnerable.
Okay, and in response to that, and I appreciate that you're raising this, and I think it's excellent that you're raising this. I would say to you that the same BC government that Senator Boisvenu mentioned, your Conservative colleague, they were here a couple of days ago, and Nikki Sharma and I had a discussion, and she's the Attorney General of BC, and what she said to me quite directly is that if you're concerned about violence against women, this bill is a huge step in the right direction, because what she's hearing about in her community in Vancouver is that specifically there are people who are being abused by their former spouses or partners at the time when those individuals are let out on bail. So the reverse onus that we're expanding with respect to intimate partner violence is a significant step in the right direction. With respect to GBA Plus analysis, I'm very pleased that you're asking me about that. I don't often get asked about that, if I'm frank, from Conservative politicians in the House. I'm glad you're asking about it here. And what I'd say to you is that it will be forthcoming. We have to redact certain information based on privilege and confidentiality, but my officials inform me that it will be forthcoming, as it has been in the past.
Thank you. Thank you.